Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. The trial of Alec Baldwin is coming up on July 9th, and I thought it might be useful to talk about how the case has been defended, why it's been defended that way, and what the likely impact of that will be on the trial judge if that defense continues in the courtroom. Now, as you know, I'm not the biggest fan of the trial judge. I thought she was unprofessional in how she addressed Hannah Gutierrez-Reed's sentencing. And of course, I disagreed greatly with several of the evidentiary calls that she made during that trial. But that's just my opinion, and you shouldn't be swayed by it. So again, that's just my perception. That's the vibe I get. I think it's important sometimes for those of us who do this and talk about trials to state our biases and our beliefs up front. And I would be dishonest if I said that I was completely neutral and dispassionate in discussing this judge, because I'm not. What I really want to talk about here is not the judge so much as the lawyers. And there's a big difference between the lawyer that represented Hannah Gutierrez-Reed and the lawyers, plural, who are representing Baldwin. They come from a firm called Quinn Emanuel. They are a very big law firm. Let's take a look at some of the pages from their website. Here you can see they specialize in business litigation. And in this particular example, look, they're the firm that most businesses fear to deal with. I'm not sure that's necessarily the best advertisement for them, but okay. Now let's take a look at their practice areas. Okay, all right, let's start with the C's over here. Crisis. I don't see anything that deals with criminal defense. Maybe it's white-collar criminal defense. Maybe we should look for that. No, I don't see white-collar criminal defense on here either, because it looks to me like you have a civil litigation firm taking on criminal defense here. And that's probably not going to end real well for Mr. Baldwin. There is this tendency among civil litigators to try every case like the last case you won. Because, hey, I won that case, and if I do everything exactly the same in this case, well, I'll win that case too. That doesn't work out for you usually, because every case is different, and you need to have the right group of lawyers, the right group of investigators, the right approach to going about doing the case that you would have if you were taking it on at the very first. And that's important because, particularly in a criminal law case, you are not dealing with the kinds of civil judgments that you are in a civil case. There are civil remedies. They don't involve jail. In a criminal case, they involve jail or prison. Now, you're probably thinking that it's just almost the same thing. I mean, their trial lawyer skills like cross-examination, those have to bleed over, right? Why couldn't a civil lawyer do a criminal law case? And the reason is this, because if a person has adjusted to becoming a civil lawyer and they're used to doing civil law, the procedures, the motions, the standards, the legal cases, the sentinel cases that you rely on are all different from the criminal law. The criminal law has its own set of seminal cases that dictate how certain things get done, how certain motions get filed, how the judge makes certain decisions in a criminal case. And if you don't have that information, if you don't have that experience and that reservoir of knowledge to bring to bear, then you tend to lose a lot of motions until you figure out what works. As a result, being a civil lawyer and going into criminal law doesn't really translate well. So the first criminal case I tried, I drafted numerous motions to suppress evidence, motions to dismiss, motions to compel, motions in limine, motions about jurisdiction. I did everything you could think of to try to get the case thrown out at the early stages. And I would file these 10 and 12-page motions with oral argument, and the state wouldn't even respond to them. They'd just show up at the motion and say, nah, don't grant it. And they'd argue, they'd give reasons. They usually didn't cite case law, but the judge knew the case law. And so I was wasting all of my time and effort and energy in putting all of this stuff in writing when what I could have done is filed a simple 1 or 2 page motion and shown up and argued it. And I would have protected my client as thoroughly as I would have if I had written these long motions. While I think my record on appeal would have been much better, when you're in the criminal law context, you want to avoid having to appeal because that means you lost. Flash forward to the Alec Baldwin case and recognize he's being represented by civil lawyers in a criminal law case. Why is that important? Because the defense bar defends cases pretty much the same way. I've said it here numerous times. It wasn't our dog. It didn't bite you. If it did bite you, you deserved to get bit. And what are you hollering about? You weren't hurt anyway. Well, that works fine in the civil law context, but not so much in the criminal law context. And as a result, these guys don't have a plan that they can follow, like they would in a civil case, to get Alec Baldwin acquitted. And that means they're developing that plan on the fly. And that is, I don't think, the best use of resources and the best litigation strategy. And again, that's my opinion. I'm not throwing shade on the lawyers at Quinn Emanuel. I'm sure they're great lawyers. I just think that if you do criminal law, you do criminal law, and if you do civil law, you do civil law, and you're smart enough to hand off stuff that you don't do all the time. I mean, there's a lot of different things that happen in a civil case that don't ever happen in a criminal case, and as a result of that, the people who have that niche for civil litigation are probably not the best prepared for criminal law. Now, about 95% of cases that are filed in civil court either are dismissed or settled well before going to trial. Usually, if the defense loses on the motion for summary judgment, there's a mediation and it's followed by a settlement. Now, that's not a loss for them. As long as the insurer doesn't have to pay the full policy limits, they take that as a win. But the majority of civil litigation kills dozens and dozens of trees. Judges in civil litigation expect to get this kind of paper storm, and they don't really like it, but they deal with it. Now, criminal judges usually don't see this because they know what the criminal lawyers are going to file. It's going to be a short pro forma motion, 1 or 2 pages, short briefs in support of those motions, and then they're going to argue the heck out of them in trial court. Most criminal lawyers just don't have time for long pleadings. They have multiple clients. They may be in court 5 or 6 times a week. So they use their words in court as opposed to writing all this stuff down because there's no limit to what they can argue standing on their feet, but there is usually a limit to the number of pages that they can file with the court. So let's take a look at the docket from the Baldwin case since June of this year. Okay, so this is State versus Alexander Ray Baldwin, and we'll click here and see what, let's go down to I think it's the 2nd of June is the first ones that start popping up here. The witness list, the third amended defendant's witness list, third amended witness list addendum, notice of withdrawal, state's opposed motion for use immunity for Hannah Gutierrez, expedited request for hearing, defendant's motion for order excluding witnesses, notice of completion of briefing, motion to exceed page limits, the defendant Alec Baldwin's reply brief in support of motion to dismiss, all these different things. Look how much paper has been filed with the court since June 2nd. And we're only to June 7th here, 5 days, and you've got probably 20 different pleadings. June 10th, Hannah Gutierrez reads opposition to the state's motion for use immunity. Yes, Hannah is actually opposing getting immunity because she doesn't want to testify. And I suspect that's because she's pretty upset about having been convicted in the first place. So the order denying, and they also served discovery on Bowles and his partner, and as a result of that, they've filed motions to quash, and the judges denied them. There's a notice of hearing, a motion in limine to preclude improper opinion testimony from the state's witness, Kent Jorgensen, all these different certificates of service, state's notice to introduce other acts evidence, meaning other acts of negligence or that contribute to the other acts or that sort of support the finding of negligence. certificates of service for all these witnesses, order denying state's motion for clarification of court's order. That's way back from 2023 that was filed or was amended, and they're just now denying a motion to clarify it. The state's response on Kent Jorgensen, improper opinion testimony. And now you see all of these things that are going on. They've filed huge briefs and lots of them. So let's take a look and see how the judge reacts to the idea of giving the defense extra pages in regard to this motion. So here's what the judge says. This matter came before the court on defendant's motion to exceed page limits. The court finds, concludes, and orders. On June 17th, defendant Baldwin filed a 32-page defendant's expedited motion for relief for prosecutorial misconduct under the rule, and then he filed an additional 237 pages of exhibits for consideration with this motion. Quick war story. We filed a response to a motion for summary judgment once in Kansas City in Judge Tom Clark's courtroom, and we included about 75 pages of exhibits, and the judge threw the pleading back at me and said, "Why don't you pick the 10 pages out of there you want me to read and then give it back?" So I became very careful about filing anything with a large number of pages without at least talking to the judge first, because a lot of times judges don't really want to see that. You can file it for the record, but you need to front load the stuff that you expect him to read, because otherwise he may not get to it. Judges have a pretty big workload, particularly trial judges. So he's filed these 237 pages of exhibits, and Baldwin did not obtain advance leave of court to file his motion well in excess of page limits. The New Mexico rules require entry of an order of a court when the party seeks to file a brief in excess of 10 pages. A brief or memorandum shall not exceed 10 pages, not including the cover page, conclusion, certificate of service, and exhibits without an order of the court. The parties shall follow all local motion practice rules, including rules on page limitations. This court has not yet ruled on several motions for consideration at the June 21, 2024 hearings. The court anticipates additional briefing on motions in limine in advance of trial. The trial is imminent. At this late stage of the pretrial proceedings, the court must enforce the local rule to regulate the court's docket and promote judicial efficiency. A court's inherent authority extends to all conduct before that court and encompasses orders intended and reasonably designed to regulate the court's docket, promote judicial efficiency, and deter frivolous filings. We caution counsel to comply in the future with our rules of appellate procedure. Sanctions may be appropriate for any future violation. So, obviously, the courts there take their page limits pretty seriously. The parties must either condense their briefs to 10 pages or explain to the court why 10 pages are insufficient to develop argument in a motion to exceed page limits. Conclusory justifications to exceed page limits are not sufficient. Motion to exceed page limits. It is necessary to exceed page limits in order for a defendant to fully brief the court on defendant's argument and for defendant to make a complete record. Well, again, that's conclusory. It doesn't really speak to why he needs additional 10 pages. The court finds defendant motion to exceed page limit is not well taken and should be denied. June 17th, motion to exceed page limits is hereby denied. It's obvious then, at least to me, that the judge is pretty tired of being bombarded with paper, maybe from both sides, but certainly with respect to Alec Baldwin's side, since that's who was hit with the motion on the page limits. The interesting thing here is that the person who is prosecuting is actually not a prosecutor. She is a defense attorney, and she understands how the game is played, and she's been very careful to keep hers all within the page limit. So it's interesting to me, there is a certain amount of hometowning that goes on in a courtroom. You tend to appreciate working with the lawyers that you routinely work with when you're a judge. over those that come in from out of town. You know, the pro from Dover who comes in and he's going to share his expertise with the court. A lot of times those people are viewed with a little bit of a jaundiced eye because, frankly, there's probably somebody he could have gotten in New Mexico who would have done him a fine job. And the local bar probably resents people coming in from outside the state, particularly New York, to handle these kinds of cases. I honestly believe this is one of those things where having somebody from a big law firm is not going to work out well for Mr. Baldwin. I've said that before. These guys tend to be people who will object to every single thing that might arguably be objectionable. And my guess is that they are going to do their best to interrupt the workflow of the prosecuting attorney in this case. And that is not going to be something that this judge is likely going to tolerate. It'll be interesting to see. I do intend to try and stream some of this trial. I'm getting all of that ready to go. We're going to probably have a stream beforehand just to make sure I don't look like a complete donkey when I do this. But at any rate, I am thinking about streaming this trial because it's an important trial and it's interesting. The issues raised are very interesting. That's what I have for you today. Thank you so much for watching. If you have the opportunity today, do something nice for somebody. Drop a comment down below. That'd be nice. Open a door. Take somebody to lunch. Do something nice. We can change the world one person, one day, one act at a time, just by doing nice things for other people. And then come on back here tomorrow, catch me down at the beach, and we'll talk about something else interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.